Generally, a sales contract that's entered into by fraud on the part of the buyer or seller isn't void, but is voidable at the election of the defrauded party. However, every false statement isn't necessarily fraudulent. In the 1918 case Vulcan Metals Company versus Simmons Manufacturing Company, the Second Circuit considered whether puffing or dealer's talk, which is offering a favorable but exaggerated opinion about a product, may amount to actionable fraud. Simmons Manufacturing Company was the first manufacturer to mass-produce woven wire mattresses in the United States. Vulcan Metals Company was a vacuum cleaner manufacturer. Around 1918, Vulcan and Simmons entered into a contract for the purchase of vacuum cleaners. Under the contract, Vulcan purchased all of Simmons's patents, tools, and equipment for manufacturing the vacuums, as well as all the parts that Simmons had on hand for $75,000. In negotiating the sale, Albert Freeman, on behalf of Simmons, represented that the vacuums were superior in terms of cleanliness, affordability, efficiency, and ease of use. In addition, Freeman maintained that Simmons hadn't previously tried to sell the vacuums, Simmons hadn't shown the technology to anyone, and the vacuums hadn't ever been on the market. However, at the time, Simmons had 15,000 vacuums on hand and had made a small number of sales. Vulcan then purchased all of Simmons's materials based on Freeman's statements. But as it turned out, the vacuums and patents were, according to Vulcan, inefficient and unmarketable. Subsequently, Vulcan sued Simmons in New York State Court for deceit, alleging in part that the statements made to procure the contract were false. The case was removed to federal district court, and following trial, the court directed a verdict for Simmons, concluding that Simmons's representations didn't amount to actionable fraud. Vulcan appealed to the Second Circuit.